Good morning, everyone. So, today we will have some basic knowledge about what is evidence law and what does Indian Evidence Act contains and teaches us. So, without wasting any time, let's start with it. First question is, how are admissions admitted? The options are A. The admission must be in writing. B. It must be oral. C. Either oral or in writing. D. Only in writing and not oral. The correct answer to this question is option C. That is, admission should be either oral or in writing. The next question is, admission to be relevant must dash. Fill in the blanks with the right options. The options are A. Must be made to a party concerned and not to a stranger. B. Must be made to a stranger. C. It is immaterial as to whom admission is made, and an admission made to a stranger is relevant. D. It is immaterial to whom the admission is made, but must be made to someone intimately connected and not a stranger. The correct answer to this question is option C. That is, admission to be relevant. It is immaterial as to whom admission is made, and an admission made to a stranger is also relevant. The next question is, proposition under the Evidence Act are: statement is a genus, admission is a species, and a confession is subspecies. The statement is first statement, admission are species and confession is a subspecies. Statement number 2, statement and admission are genus and confession is a species. And statement number 3, in this context, which are the next question is, admissions can be admitted in what ways? The options are A. Formal only, B. Informal only, C. Either formal or informal, or D. Only formal and not informal. The correct answer to this question is option C. That is, admission can be admitted in either formal or informal way. The next question is, admissions are of what nature? The options are A. They are conclusive proof of the matters admitted. B. They are not conclusive proof of the matters admitted but operate as a estoppel. C. Are conclusive proof of the matters and also operate as an estoppel. And D. Both A and C are correct. The correct answer to this question is B. That is, admissions are not conclusive proof of the matters admitted but operate as an estoppel. The next question is, the person who can make admissions are mentioned in which of the following sections? The options are A. Section 17 of Evidence Act, B. Section 20 of Evidence Act, C. Section 19 of Evidence Act, or D. Section 18 of Evidence Act. The correct answer to this question is option D. That is, a person who can make admissions are mentioned in Section 18 of the Evidence Act. So now let us see what does Section 18 of the Evidence Act states. After knowing that, let's move on to the another question. That is, admissions by agents are A. Admissible in civil proceeding under all circumstances. B. Admissible in civil proceeding only if the agents has the authority to make admissions. C. Never admissible in criminal proceeding, or D. Both B and C. The correct answer to this question is option D. That is, both B and C are correct. That means to say, admissions by agent are admissible in civil proceeding only if the agent has the authority to make admission and are never admissible in criminal proceedings. So let's move on to the next question, which is, admissions made by a party are evidence against whom? The options are A. Previous in blood, B. Previous in law, C. Previous in estate, or D. All of the above. The correct answer to this question is option D. C. That is, the admissions made by a party are evidence against previous in estate. Then moving on to the next question, which is, which of the following admission is no evidence? The options are A. An admission made by one of the several defendants in a suit against another defendant. B. An admission by guardian ad litem against a minor. C. An admission by one of the partners of a firm against the firm or other partners. Or D. Only A and B. The correct answer to this question is Option D, that is only A and B are the admission in no evidence. That means to say an admission by one of the several defendants in a suit against another person and an admission by a guardian ad litem against a minor is no evidence. The question is, when the liability of a person who is one of the parties to the suit depends upon the liability of a stranger to the suit, then the admission by a stranger in respect of his liability shall be admissible on the part of that person who is the party to the suit. It has been so provided under which of the following sections? The options are A, under section 21 of Evidence Act, B, under section 20 of the Evidence Act, C, under section 19 of the Evidence Act, or D, under section 17 of the Evidence Act. The correct answer to this question is option C, that is under section 19 of the Evidence Act, the above principle or the law has been stated. The next question is, in reference made over a disputed matter to the third person, the declaration so made by that person shall be an evidence against the party making a reference, by the virtue of which of the following sections? The options are A, section 17 of the Evidence Act, section 19 of the Evidence Act, section 20 of the Evidence Act, or section 21 of the Evidence Act. The correct answer to this question is option C, that is section 20 of the Evidence Act. So now let's see what does section 20 of the Evidence Act states. The section 20 of the Evidence Act states the admission by a person expressly referred to by a party to a suit. This section states that statements made by a person to whom a party or to a suit has expressly referred for information in reference to a matter in dispute are admissions. The next question is, communication made without prejudice are protected under which of the following sections? The options are A, under section 22 of Evidence Act, B, under section 23 of the Evidence Act, C, under section 24 of Evidence Act, or D, under section 21 of Evidence Act. The correct answer to this question is option B, that is section 23 of the Evidence Act states that the communication made without prejudice are protected. Now let's see what does section 23 means. It states admission in civil cases when relevant. This section states that in civil cases no admission is relevant if it is made either upon an express condition that evidence of it is not to be given, or under the circumstances from which the court can infer that the parties agree together that evidence of it should not be given. The explanation to this section is that nothing in this section shall be taken to exempt any barrister, pleader, attorney, or vakil from giving evidence of any matter of which he may be compelled to give evidence under section 126. The next question is, the confession made by inducement, threat, or promise is contained in which of the following sections? The options are A, section 24 of the Evidence Act, B, section 25 of the Evidence Act, section C, section 26 of Evidence Act, or D, section 27 of the Evidence Act. The correct answer to this question is option A, that is section 24 of the Evidence Act states confession caused by inducement, threat, or promise is contained. Now let us understand section 24. Section 24 states confession caused by inducement, threat, or promise when irrelevant in criminal proceedings. This section states that a confession made by an accused person is irrelevant in a criminal proceedings if the making of the confession appears to the court to have been caused by any inducement, threat, or promise, or having reference to the charge against the accused person proceedings from a person in authority proceeding from the person in authority and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supposing that by making it he would gain any advantage or avoid any evil of a temporal nature in reference to the proceeding against him. A confession made by the accused person is irrelevant in criminal proceedings if the making of the confession appears to the court to have been caused by any inducement, threat, or promise having reference to the charge against the accused person proceeding from a person in authority and sufficient in the opinion of the court to give the accused person grounds appeared to him reasonable for supposing that by making it he would gain any advantage or avoid any evil of the temporal nature in reference to proceeding against him. Now moving on to the next question, section 24 of the Evidence Act applies to which of the following? A. When the inducement, threat or promise comes from a person in authority. When the inducement is of a temporal kind. When C. When the inducement is spiritual or religious. Or D. Only A and B are correct. The correct answer to this question is option D, that is only A and B are correct. That means to say section 24 of the Evidence Act applies when the inducement, threat or promise comes from a person in authority and when the inducement is of a temporal kind. Moving on to the next question, that is a confession made to a police officer is inadmissible under which of the following sections? The options are A. Section 24 of Evidence Act, B. Section 25 of Evidence Act, C. Section 26 of Evidence Act, and D. Section 27 of Evidence Act. The correct answer to this question is option B, that is Section 25 of the Evidence Act talks about the confession made to a police officer is inadmissible. So let us understand what does Section 25 states. The Section 25 states confession to a police officer not to be proved. No confession made to a police officer shall be proved as against a person accused of any offence. No confession made to a police officer against person accused of any offence. This was the end of our first presentation. Hope you all liked it and hope this presentation or video was able to teach you something about the civil procedure code. Thank you for watching it. Thank you.